Hello, my name is Dustin Draper. I'm an attorney here at the Packard Law Firm, and I'm the managing partner of the Social Security Disability practice here at the firm. Now, I'd like to welcome you to this presentation where we're going to talk about a lot of very important principles and concepts that will help improve your odds of getting your Social Security case approved, hopefully as quickly as possible. We'll also talk about the timeline and what to expect. Now, first, let me give a little bit of background on my experience. I've been working in Social Security for 10 years. I've been a licensed attorney since 2014. I went to law school at the University of Texas, and I've worked on cases at all stages from the initial application all the way to the appeals council and district court cases. Also, I have personally handled over 600 disability hearings. And so I feel like at this stage in my career, I have a pretty good idea of the way Social Security analyzes these cases and what things a person can do to help give themselves the best chance of winning. So with that, let's go ahead and get into our presentation. Let me go ahead and show this to you. Okay, so today we're going to be talking about three main concepts. First, the Social Security process. What can I do to improve my odds of winning? And then finally, a great tool that we have for our clients called Case Status. They can make communicating with us very, very easy for you. So first, let's go ahead and talk about the SSA process. All right, so when you apply for Social Security disability benefits, there are typically four main stages. When you first apply, there is an initial claim, and if the initial claim gets denied, then you file an appeal called a reconsideration, and then if the reconsideration gets denied, then you can request a hearing in front of a judge, and then finally, if the judge denies your case, you can go to appeals council. Now, there is one additional stage here that I haven't listed. It's called district court, and that's after the appeals council. However, it's a very small selection of cases that will actually go up to a district court. So we're not going to really be talking about that as much today. Today, what we are going to be talking about is the initial claim and reconsideration stage. And then we'll go on from there. Okay, so first of all, at the initial claims, let's talk a little bit about what happens when you first file your application for Social Security, because for a lot of people this is a mystery. You file your paperwork and then you wait a very long time and you're not really sure what Social Security is doing with your case. So let's explain that in a little more detail, exactly what happens. So the first thing that happens is when Social Security receives your application, either online or through the mail, the application gets sent to your local Social Security office, sometimes known as the field office. And they do some initial processing of your case. They're going to double check to make sure that you're eligible and that they have all the information they need from you. After that, they take the case and they transfer it to a centralized office called DDS. And there is one office in every state in the United States. So in Texas, for example, there is an office in Austin that handles these cases. And DDS stands for Disability Determination Services. And what they do is look at the case and basically they're in charge of deciding if you meet the qualifications to receive disability. And most of that focus is if you're actually medically disabled. And so as part of that analysis, they will order all your medical records that you listed on your initial application. Then they'll take the medical records and send them to a medical doctor to have him review and offer an opinion about your limitations. And finally, they will issue a decision in the case. Now, normally this process will take 4 to 6 months. However, I have to say that sometimes this does vary. And unfortunately, here in the year 2022, we are experiencing significant delays in the timeline. So I want to show you an article that that we received recently. This is from NOSCR, and NOSCR is an organization of basically it's a national organization of Social Security attorneys, and they release a monthly newsletter. And in April 2022, the headline story was this: that the DDS backlog exceeds 1 million cases. So nationwide, there are 1 million disability cases that are still waiting to receive a decision, and that is unprecedented. The last time they had a backlog that large was after the financial crisis in 2008. So it's very unprecedented for them to be that delayed. Furthermore, they go on to list out the 5 states with the worst backlogs, and those are first Texas, then Florida, then California, New York, and Georgia. So unfortunately, if you are in the state of Texas, this issue that they're having is significantly worse. So we are seeing timelines that is, I know I said typically it's 4 to 6 months, but for many of the cases we're handling right now, we're seeing timelines that are twice as long, like 8 to 12 months. And, that is just ridiculous. But this is a nationwide problem. If this has happened to you, don't feel like you've fallen through the cracks. This is happening across the state, across the nation. Now, Social Security, I've reached out to Social Security. I've been to several different conferences, and I've heard different excuses from the agency, but at a NOSCR conference I attended this year, they had a Social Security representative come speak, and they indicated that they're having an unprecedented level of turnover among their employees. And so they're just not used to being able to replace employees as fast as they've had to in the past year. And that's the main reason for the backlog. So I know this is very, very frustrating, but there really is not much that you can do on that. But I do want to mention a few ideas. There are a few situations where Social Security will expedite a case. And typically they don't like to expedite cases, because if they decide to expedite your case, what they're doing is they're basically putting you in front of other claimants who have been waiting longer than you for a decision. And so generally, in the interest of fairness, they like to avoid that. However, if you have a foreclosure or eviction notice, if you have that in paper, send that to us, because they oftentimes will expedite cases in that circumstance. Also, heaven forbid this be the situation, but if a person is terminally ill, then they will also expedite that. So if you have something from your doctor indicating, the time you have left, that they will expedite those cases. And then the third situation is where Social Security, if you're part of the Wounded Warriors program, which is a VA program, then those cases automatically get expedited, but those are pretty rare. Okay, so those are the 3 situations. Outside of that, there really are not any tricks to making the case go faster. Okay, so that's what happens at the initial claim stage. Now, a lot of people want to know what their odds of winning are when they first apply. So let's talk about that. So when you first file your application, 20 to 30% of those will get approved. So out of 10 cases, 2 or 3 will get approved. Now, I will say, if you are under the age of 40, your odds of winning at each stage will be lower. On the other hand, if you are above 50, your odds of winning at each stage will be higher. And the reason for this is that usually the younger you are, the more skeptical Social Security will be about your claim, because they recognize that when you're younger, you're usually more resilient, your body heals faster, and so they're more skeptical. And then when you're older, Social Security is more sympathetic. They realize that your body can't heal itself as well. But also there's some specific regulations that will apply to your disability case once you turn 50 years old that make it easier to get approved. And then there's another set of rules that apply when you turn 55 that also help you get approved easier. And so your odds are definitely higher once you reach the age of 50 and the closer you get to retirement age. Okay, so now let's talk briefly about the reconsideration stage. This is very similar to the initial claim stage because the case is going back to the same office. It goes back to DDS. They again order records. They again have a doctor review it and issue a decision. Now, typically this does go a little bit faster, and so it's 3 to 6 months. But again, the same issue applies where we're seeing delays where the cases are taking twice as long as what we normally see. Okay, now at reconsideration, I do want to let you know that the odds of winning at this stage are lower. It's typically 10 to 20%, so about 2 out of 10 cases get approved at this stage. And again, like I said before, odds are lower when you're younger. They're higher when you get older, especially when you turn 50 years old. Okay, now one thing that does happen at the initial claim and sometimes at reconsideration is that Social Security will often ask the client to fill out paperwork. So if your case is at reconsideration or the initial claim, you always want to be checking your mail regularly. And if for any reason your address changes, do let us know so that we can update Social Security. Of course, we independently are checking on your case to see if anything is needed, but this can just be an extra layer of protection for you. Okay. Now, for most people, their case will be denied the first 2 times, and they will have to request a hearing. So I do want to briefly talk about what happens at the hearing stage. So when you request a hearing, there's unfortunately the timeline on the hearing is the longest. Okay. But your odds of winning are the best when you're at a hearing with a judge. So let's talk about what happens here. So first, you file an application. It gets processed by your local Social Security office. Then the case gets transferred to the OHO office, which is the Office of Hearing Operations. They then take the case and prepare an electronic file, because if you're going in front of a judge, your attorney is going to get access to all of the paperwork in your case, and they do that through an electronic file. Now, usually once they put all that together, the case sits for many months until there's space that opens up on a judge's docket so that it can be assigned to a judge. And the reality is they just don't have enough judges to handle the number of cases that come through. So there's often significant delays here. Now, once a judge gets it on his docket, they then schedule a hearing. They will typically give at least 75 days notice of the hearing in advance, so you have time to prepare for it. And then you have the hearing with the judge. And then after the hearing, the judge will typically take a few months and then issue a written decision. Okay, so the timeline for this process is typically 8 to 12 months. And that is 8 to 12 months from when you request a hearing to when you walk in to talk to the judge. I say walk in, but the hearing in many cases might be by phone or by video. So yeah, that's 8 to 12 months. And then typically it's another 2 to 4 months after the hearing before you receive the decision. So it can be unfortunate. And now I will say that your attorney, sometimes the judges will do things during the hearing that will indicate that the judge is likely to approve the case, and your attorney can explain that after the hearing. They don't always do that, but certain judges do. Okay, and I will say that the delays that we've seen with initial claim and reconsideration during the year 2022, we have not seen yet at the hearing office, and hopefully they continue processing claims quickly. Okay, now your odds of winning at the hearing are the best they'll ever be. Okay, typically just over 50% of cases get approved in front of a judge. So, it's like flipping a coin. And of course, if you're younger than 40, the odds are lower. If you're over 50, your odds are higher, especially if you're 55 or 60 and above. So that's all good to keep in mind. I also do want to let you know that there's a lot of variation in win percentage based on the judges. There are some judges that approve less than 20% of cases, and there's other judges that approve close to 80% of cases. And so your judge is one of those variables that can play a big role on whether you win or lose your case. Okay, and then the final stage is the appeals council. Okay, now the appeals council, if your case is denied by the judge, you have the option, and many people will choose to appeal the judge's decision. And to do that, it is with the appeals council. Now, many people will choose to file a new claim. And the truth is there's good and bad to both of these options. So we typically don't recommend one or the other. But if you do choose, after speaking to your paralegal, if your hearing is denied, and you decide to go to appeals council, then what happens is the case gets transferred to a national office. There's one in Falls Church, Virginia, that they typically go to, and it's reviewed kind of at the centralized authority. And at this stage, what they're reviewing is what the judge did, how the judge handled the case, and they're primarily looking for just an error that the judge made in reviewing the case. If the judge decides that, or if the appeals council thinks that the judge overlooked something, then they will typically send the case back to the judge to have him do a new hearing. Okay, that's called a remand. Now, sometimes the appeals council will look and just decide that they have enough evidence to approve the case, and in which case they'll just approve your case. Okay, and again, typically this process is 8 to 12 months, and the odds of winning again are about 10 to 20%. So out of 10 cases, one or two out of 10 will get approved at this stage. Okay, because it's such a long time frame and the odds are not super high, for many people they feel more comfortable filing a new claim. But again, we'll explain that to you about those options, but you can always decide kind of which way you want to go. Okay, now if your case is denied by the appeals council, there is one higher level. I'm not going to go into this at this stage, but we always review cases to consider whether it would make sense to file an appeal above the appeals council, which this would be a district court appeal. And again, if that applies to your case, we will talk to you at the appropriate time. Okay. All right. So that is the timeline that you can expect on your Social Security disability case. Okay. Now let's talk about what I can do to improve my odds of winning. Okay. So we have a picture here of some dice, and I want to tell a story here of when I was hadn't been an attorney very long. I had a judge that became a mentor to me that I was very close to, and he would always give me helpful advice on how to be a better attorney. And after one of my first hearings, the judge pulled me aside, and he could see that I was bothered by how arbitrary these cases are. I remember feeling very frustrated because I would have some cases that I felt like didn't have very good evidence, and those cases would get approved. And then I would have other cases that I felt were amazing, where we had incredible evidence, and yet we would be fighting tooth and nail to get the case approved. And it was very frustrating. And so the judge, seeing this, he pulled me aside and he said, look, there are a lot of things in the practice of law that you can't control. You can't control who's going to decide the case, what judge you're going to get, and there's just things that you can't control. But and the reality is, because of that, you are going to win cases that you shouldn't win, and you're going to lose cases you shouldn't lose. But what matters most is that after each hearing, you can go over there to the bathroom and look yourself in the mirror and say to yourself, I did the best I could. And if you can do that, then you can live with the results. Okay, now he was giving me this advice as an attorney, but I think a very similar thing could be I could say to each of my clients. And because I know that all of you probably know somebody who is receiving disability benefits who does not seem very disabled at all. And yet here you are still fighting with Social Security over your case. And I know how frustrating that can be. Believe me, I've seen it. I've seen all these cases, and I've seen how arbitrary it is. But the name of the game to win this case, just think of it this way. Every time you apply, every time you appeal, you are rolling the dice. Okay? And so there is a certain probability you're going to win, and there's a probability you're going to lose. And you just have to realize that that's just the way it goes. And you can't be hung up on the things you can't control. For example, like which judge you get or how strict they are. But you want to focus on the things you can control. And if you do that, you're going to give yourself the best chances of winning. And if you're giving yourself the best chances, then you keep fighting, you keep rolling the dice, and eventually you likely will get approved. Okay? And believe me, saying this as your attorney, you just have to keep in mind that we don't get paid unless we win your case. So I have no incentive to tell you you have a good case if you really don't. Okay? If we are representing you on your case, then it's because we feel like the case has merits and you have a great shot of getting the case approved. Okay, so before I get into specific tips for how to get your case approved, I want to take a minute to help you try to see things from the perspective of Social Security, because if you can understand where they are coming from, you will know how to prepare yourself better for how they're going to do your case. So there's a quote here that I've put up. To truly understand others, we must first learn to see things from their perspective. So with that in mind, let's take a look at the way Social Security views your case and what their perspective is. Okay, so let's say when Social Security receives your file, whether this be the DDS office at the initial claims or the judge, when they start look at your file, the first thing they're going to see is a list of what the health problems are, what your diagnoses are. And that's fine, and they'll accept those. They're not going to dispute what the doctors are saying. But one of the mistakes that many people make is that they think that if they have a diagnosis, that equals the disability. And that simply is not true. At least it's not true under the Social Security regulations. The diagnosis is not what will get you the benefits. It's not about the diagnosis. It's about the limitations. Okay? And so to take this a step further, let me kind of walk down the path of the way they are looking at your case. So they get your case, they see all these diagnoses that the doctors have given you, and they're going to say, okay, I get it. You have all these medical conditions, and you probably can't do most work out there because these are severe health problems that you have. In fact, you probably can't even do your past work that you're used to doing. However, and this is the key, so listen very carefully. This is the next step in their thinking. However, even though you have those severe medical conditions, most people with that condition are able to work. So what is it that makes your situation so much worse than all those other people that are able to work? Okay? And so, you can think of this. Let's just use an example. Let's suppose that you have diabetes. If you have a diabetes and you're on insulin and your sugar, your A1Cs are above 10, they will look at that and they'll say, okay, yeah, that's pretty bad. And that's going to make it hard for you to work. But most people with diabetes have a job. Okay. And this goes really pretty much for any condition, back issues. Most people with spine problems do find a way to work. Okay. So it's all about showing them that your condition, that it's not like what most people have, that your condition is significantly worse than average, or that you have a combination of conditions that affect you in a way that prevents you from working. Okay, and that's really what these cases come down to. Okay, two other things that I want to point out that are important that Social Security decision makers are well aware of. The first one is that you, as the person applying for benefits, and me as your lawyer, we have the burden of proof, not Social Security. We have to establish what these conditions are. So they don't have to prove that you're not disabled. We have to prove that you are disabled. Okay? And then the second point is, and I don't know, I've never had a Social Security employee talk about this, but I get a feeling from them that this is in their brain. And that is how much money is at stake on these cases. So let's suppose that you're 45 years old and you're applying for disability. That's a kind of an average age for people applying. Well, when you're asking for your disability benefits, you're essentially asking for your Social Security retirement 20 years early. And if you're getting that 20 years early, if you look over that, let's say the average benefit between your monthly check and the insurance is easily, that's worth $2,000 a month. Okay, $2,000 a month, 20 years early, that's about $500,000 of benefits that you're asking for. So if somebody came to you asking for that much money, you would really be cautious about giving away that much money. And I do feel that many of these Social Security employees and judges realize that, they are employers of the government, and they have a duty to make sure that these benefits are not wasted on people that really haven't proven that they're disabled. Okay? So again, that's Social Security's perspective. Now, I'm not saying I agree with the way Social Security looks at your case. I do think that they take this too far, but this is how they look at it. Okay? So with that said, let's kind of zoom out here. And now let's talk about this idea, right? Which is how you're going to show Social Security how your situation is different. Okay? And there really are two parts to this. The first part is what your story is with Social Security, and the second part is what evidence you have to back up that story. So, in order to think about how this applies to you specifically in your case, I want you to answer this question. You can even pause this video. What is it that prevents you from working? I mean, really, why can't you do a really easy sit-down job? Okay. Now, some of you might be tempted to answer with a diagnosis. But again, your diagnosis does not make you unable to work. It is your limitation. So you have to take it one step further. You have to think about, if you have diabetes, what is it about your diabetes that would make it so you could not do an easy sit-down job? Okay, you've got to be as specific as possible. So since I'm using diabetes as an example, let me kind of show you what that might look like. It might be that, well, I have diabetes and I'm on insulin, but the reason I couldn't do a really easy sit-down job is that I have extreme problems using my hands because of my neuropathy. And so it makes it hard to do anything like write on a piece of paper or type something or handle small objects because of my hand pain. That's it. Okay, that's very specific. Okay, or it might be, your story might be that, because of my diabetes, I have flare-ups where my blood sugar will spike and it will cause extreme problems. And so that will happen about once a week, and I'm out of commission for a day. That might be the specific reason that you give. Okay? Or it might be a combination of these, or if you have multiple conditions, a lot of times it's multiple issues, okay? So that is your story, okay? Now, when you're saying that to Social Security, you're making a claim. I can't work because I can't use my hands, okay? Now, once you make that claim, you think of this like you're building a house, okay? And that your claim as to why you cannot work is the roof of the house. And you have to support the roof, okay? It's not just going to stay up on its own. It needs support. And your claim needs support, all right? And the primary support that you're going to give for your explanation about why you can't work is the medical record, okay? So when you go to a doctor and you talk about the problems with your hands, you're adding support to that claim of having hand problems, okay? But if you don't go to the doctor, or if you're not mentioning problems with your hands consistently over time, then your support is going to be very weak. It's really just going to come down to your testimony. And that will not, Social Security is not going to believe you just because you say what is going on. They've got to have proof, okay? And so your main focus throughout this whole process should be, what can I do to really make sure that I've gotten good medical evidence that supports the story I'm telling Social Security, okay? So if you can start seeing a doctor more often, or if you can get the doctor to offer an opinion about your limitations, and if you can go see a specialist, the more you're doing, the over time you start building up a very strong case. Okay, now with that, let's go ahead and talk about specific actions you can take. But again, I just want to reiterate this point one more time. I'm going to kind of restate it in a different way. The most important reason people lose their disability case is because the story they tell Social Security is not supported by their medical records. Okay? If you tell Social Security that you have seizures once a week, they will be looking in the medical records for documentations of seizures that are happening once a week. If it's not there, it doesn't support it, they won't believe you. Okay? So, let's then get into very specific things you can do to increase your odds of winning. First is just frequency of treatment. The more you go to the doctor, the more likely you are to win. If you have two identical people with the exact same, they're clones of each other and they have the exact same medical conditions, but one of them goes to the doctor once a month and the other goes once every 3 months, who are you going to think is worse off? You'll naturally think the person who's going to the doctor more. And Social Security is the same way. Also, it's important to keep in mind that Social Security will look at what type of specialty treatment you get. If you're going to get treatment at a specialist, Social Security will interpret that as a sign that your condition is more advanced, that it's more severe. So do your best to try to get treatment from specialists, okay? And the specialist that you would want to go to will depend on what your primary disabilities are. So, if it's a seizure disorder, you're going to usually a neurologist. If it's a rheumatoid arthritis, you're going to a rheumatologist. So the specialists really do help. Okay. Now, one of the questions that somebody asks is about mental health treatment. So you do want to be seeing a specialist, which would be a psychiatrist. The problem is psychiatrists typically won't see you that often. So you always want to supplement that with treatment from a talk therapist. So that's like just a counselor, and they'll usually document a little bit more, but you really want to be hitting both as much as you can. And again, you want to, I'm getting ahead of myself here, but yeah, the more you go see a specialist, the better. Now, of course, the best type of treatment that you can receive, the thing that will signal to Social Security more than anything else that your condition is very severe and disabling is like the max levels of treatment, which would typically be hospitalization, surgeries, or any type of MRIs, like expensive type of imaging that will reveal severe abnormalities. Okay. Now look, you can't really control whether the doctor has you hospitalized or does a surgery, but typically if you're going to the doctor more often, it's more likely that you'll get these type of recommendations. All right. Next is, once you're going to the doctor as much as possible, it's very important that you are always telling the doctor about your key limitations. Okay? So not all health problems are created equal, because certain types of symptoms will impact work more significantly than others. So if you have sleep apnea and it's hard to get a good night's rest, yeah, that does affect you, but that's not as applicable to working as if, let's say, that you had problems using your hands. If you have problems using your hands, well, that impacts just about any job out there. So that is also, that's a very important limitation, and that's much more important than, something like sleep apnea. So again, you want to be, the way to you figure out the key limitations is you go back to that question: why do you think you cannot work? What would happen to you at work? And whatever those specific things that would happen, those are the things that you want to be telling the doctors about. Okay? And some issues are things that cause you difficulty to do the work. So, and the most useful limitations in this area are difficulties using your hands, or like lifting things, difficulties standing for very long, and difficulties sitting. Okay, those are very key limitations. If you have any problems like that, you've got to be telling the doctors about those issues, because that will knock out so many of the jobs that Social Security will be looking at. The other types of limitations are, there are certain limitations that don't prevent you from doing the work, but they make it hard to stay on task. So these might be conditions that cause you to have good days and bad days. So let's suppose that you have really bad, let's say you have Crohn's. I've had a lot of clients with Crohn's disorder, and if you have that, you'll have every month you usually have a few days where you just have a flare up in your symptoms, and so for 2 to 3 days a month you're just knocked out. You're in bed taking lots of medications, taking it easy. Okay, that's a good day, bad day, and a lot of different conditions have these. Could be that you have lupus and you have flare-ups occasionally. So you've got, if that is your reason for not being able to work, is because you have these bad days, you've got to be telling the doctor about that. And you've got to be specific with the doctors. Okay? You can't just say, oh, I have some bad days. That's not nearly as helpful as if you go to the doctor and say, once a week, I have a bad day where for 6 to 8 hours during the middle of the day, I'm puking in the bathroom, or I'm laying in bed. That's a very specific description. Okay. And then another variation on this are flare-ups that could happen at any random time. So it might be a migraine disorder or a seizure disorder. So those definitely impact your ability to work, because they're going to cause you to be off task. But again, we've got to see that in the medical records. So if you have migraines, you've got to be telling the doctor specifically how often, the frequency and duration. How often do they happen? How long does it last? Okay, same thing with seizures. How often are the seizures? What type of seizures are they? And how long are you kind of wiped out? I know the seizure usually lasts a short time, but then how long are you kind of like laying in bed? Is it the rest of the day, or what is it? You've got to be specific with these doctors. If we don't see specific mentions of these issues repeated over time, it'll be much harder to establish your disability with Social Security. Okay? Next principle is this. The doctors do not write down everything you tell them. And so you need to be consistently telling them about those key issues that you have. Okay? Now, the most classic example where this happens, it comes up, is with side effects of medications. Okay? So doctor gives you a medication, and if you have real severe side effects, that will be relevant to your ability to work. And if that's the case, you need to go tell the doctor. But what happens is sometimes people tell the doctor the side effects. The doctor says, oh, I'm sorry, there's nothing we can do about that. And then they stop mentioning it. And when Social Security sees it only mentioned once, they'll think, oh, it must have gone away. And so you've got to, if you're having something like that, you've got to be telling the doctors every time. But this goes beyond like side effects of medications. If you have pain sitting, every time you see the doctor, you've got to be telling him about that. And this is not just when you're seeing the doctor. This is when you're filling out the worksheet asking about your symptoms. You need to be writing that down if that's what you're experiencing. When you go see the nurse before the doctor sees you, you need to be telling her about that. And then when the doctor comes in, you need to be telling him. And even if the doctor tells you, look, I'm sorry, there's nothing I can do with this, you got to live with it, you thank him for his help, but that's not going to prevent you the next time you see him from bringing it up again. So it's very, very important. Yeah, so always be telling the doctor about what those problems are. It's so common for a person to go tell a judge, I have all these issues that go on, and then the judge looks in the medical and can't see those mentioned anywhere. Okay, so that's very, very important. Okay. Now, I had a client ask, sometimes the doctors, like I found that a doctor didn't document what was going on. Maybe you got a summary of the visit. And if that's the case, you want to be kind to the doctors, but you do want to bring it up to them. And I do it in a kind way because, look, the doctor is there to help you out. And so you don't want to make enemies with them. But you do want to bring it up. Just say, hey, look, it's important that we document what happens at these visits. And and you can show him your record that you have and say, look, I mentioned this, but I don't see it in the record. And not that you need to be going through and reviewing all of your records. I'm just saying, if you do find yourself in that situation, that's something you can do. Okay, next piece of advice is this. Assistive devices, canes and walkers, they can be very helpful to your case because they can have a real impact on your ability to do certain types of jobs. They can be very helpful to your case. However, they are not very helpful if Social Security cannot see a prescription for them. So if you're using a cane, this happens a lot, where a person, they'll have difficulty walking, they'll just go into CVS, buy a cane, and then the doctor will see that they're using a cane, and the doctor will think, well, I don't need to prescribe it because they're already using it. Well, as your disability lawyer, I really need to see the paper trail here. I need to see that the doctor is recommending that you use the cane. So if you need a cane or a walker or whatever the assistive device is, then you need to get a prescription from the doctor, and you can talk to your doctor about this. Also, if the doctor has prescribed you to use a cane, you actually should use it. And again, this doesn't happen very often, but I have seen a case where an orthopedic specialist prescribes a cane and the person uses the cane, but then they go see another doctor and they don't bring their cane. They're just kind of making do without it. Well, the doctor then writes down the person ambulating without a cane. And, if that in that case, that's probably not a very good look from Social Security, because yes, they see that the doctor recommends it, but if you're functioning without it, then, it just casts some doubt on whether you really need the cane. Okay. The last thing I want to mention are medical opinions. Okay, now medical opinions can be very helpful. So if your doctor has never written a letter describing what your limitations are, it's worth exploring this. Now, we actually do have a form that we've custom designed that kind of matches the Social Security regulations, and we can send you a copy of this to have your doctor fill it out. Now, many of these doctors, they do want to charge for you to fill out these forms, and we're willing to either pay for the doctor to take the 5 to 10 minutes to give an opinion, or to reimburse you if they charge you for a visit. Okay, we reimburse up to $75 for these medical opinion forms. And so if you would like a copy of these forms, you can contact your paralegal here at the Packard Law Firm. Their information's in the case status app, and they can get that to you. And those can be very helpful. Okay, so those are specific things that you can do to improve your odds of getting approved. Now, one thing I do want to mention, a few things that can be harmful to your case. There are two things that you really want to be careful about avoiding. The first one is non-compliance, okay? Because the last thing you want is for Social Security to think that you can't work because you're not following the doctor's instructions. You don't want to be that type of person. That reflects very poorly on you. You want to be showing Social Security that you're doing everything you can to get better. And so that includes being a good patient to the doctor. Okay, so if the doctor gives you a medicine and it causes some severe side effect, one approach would be to stop taking it, and then when you go see the doctor, tell him what happened. But a better approach would be to immediately call the doctor's office and report the side effects, and then see what they want to have you do. Okay? So that's one thing. Another thing that can be very harmful to your case is drug or alcohol abuse. If you have a drug or alcohol problem, it's going to show up in your medical records. You won't be able to hide that. And so if you happen to be, if you're not in that situation, be sure to stay clean from those issues, because those really will hurt your case. However, if you do have a problem with those issues, then you need to get treatment. Social Security will be sympathetic to drug or alcohol abuse if they see that you're making honest attempts to get better. Okay, I've won plenty of cases of people that are recovering alcoholics or recovering addicts that are going to the Alcoholics Anonymous meetings, the Narcotics Anonymous meetings, and they can show that, look, I am working to get better. They don't expect you to be perfect, and they realize that, you know, nobody's perfect. People make mistakes. So that's another important thing to consider. Okay. One final thing that I do want to address, one common question that people have is how working might affect their odds of winning. Okay. And so I give some general advice on this. Generally speaking, you can still continue your claim for disability benefits while you are working. But the amount of income that you make can impact your disability case. So it's worth understanding that. Now, in my experience, if you make $0 to $500 per month before tax, they usually will have little to no impact on your case. I really don't even worry about those situations. Now, if you make above 500, technically you can make up to about $1,350, I think is the limit. But the further you are above 500, the more likely it will hurt your case, because Social Security starts to become skeptical if you really are disabled, even though you're making, say $1,000 a month. And again, that's before taxes. Now, if you happen to go back to work full-time, we can still continue your case. That's called a closed period case. And basically what we explain to Social Security is that, look, my client was disabled, their health was bad, however, they've improved now, and now they are able to work. And then you don't get ongoing benefits, but you get a lump sum of benefits for all that time, all those months where you were out of work. So that can be a lot of times a lot of money. And then it's also possible that Medicare or Medicaid can pay for some of your if you have past due medical bills. Okay, last topic we're going to talk about is the Case Status app. Okay, this is a new tool that we're very excited about. But first, let's talk about why it is that we have invested so many resources into this tool. Okay, so what is the number one complaint that people have about their attorney? This is something that, as an attorney, I've read lots of articles about, how to be a good attorney. Well, the most common complaint that I see in these articles is poor communication. And the Packard Law Firm, we have independently been surveying our clients for the past 5 years. And the most common advice that our clients give us about what we could do to be better attorneys is improved communication with clients. And so we really do listen to our clients. In fact, this webinar that you're participating in is also a suggestion from a client. So we really do take this to heart when you give us feedback. And so case status is essentially a tool that makes it very easy to communicate with us. And it's not something that you have to use, but it's something that can be very helpful in your case. So let's talk really quickly about what case status does. So first thing it does is once a week, case status will receive an update from our software, and it updates every single case, and it will send you a notification if your case has advanced to a new stage. And these updates come once a week, so they're very, very new updates. Also, if by chance your case is in one stage and it's waiting for Social Security for some time, we will check in at least every 2 weeks saying, hey, we're still working on your case, still no updates, but we do still have your case, we still are checking on it. Let us know if you have questions. So that way we're staying in touch with you. All right. Also, when you open up the app on your phone or on your computer, it will give you a timeline and you'll see exactly where you are on the timeline. I kind of compare this to the pizza tracker. I think, what is it? Pizza Hut has that, and it's a similar concept, but this is for your disability case. So you can see where you're at in the timeline, and you'll also be able to see descriptions of each stage in the timeline and what to expect at those stages. There's also a direct messaging feature in the app. This works a lot like texting. You can even take pictures and send them through the messaging. If you access the app on your computer, you can also attach documents to it, like as if it were an email, and we'll receive that. Okay. Finally, there is a medical treatment log, which can be a very useful way for you to keep track of all the places where you've received medical treatment, because we will periodically be asking you for updates on where you've been treating. But if you're logging all that treatment in the app, we'll automatically be able to see that, and a lot of times that can help us file appeals faster in your case. The last helpful thing is that case status has all the contact information for your team, including your paralegal, the case manager, the attorney. And these are the direct contact. Like, you can see the direct contact information for your case manager. That's the direct phone number and the direct email. So that can be helpful as well. Okay, and then finally, let's just talk about some frequently asked questions. First one is, do we have to use the case status app? Absolutely not. You do not have to use it. I do have a few clients I've spoken to that they're a little more old school. They just want everything done by email only, or they prefer everything done just by phone. And that's fine. We're adaptable to your needs. If you tell us you want your case handled a certain way, 99% of the time we can adapt to those preferences. So if you don't want to use the app, you don't have to. And in fact, you still, those updates that go out, you'll still receive them. If you're not using the app, they'll just come through as a text message, and then you can respond to the text message and we'll receive those updates. Next is, how do I log in? So if you have a smartphone, you can download the app. It's on iPhone and Android. We can send you a link for the download. If you don't have it, you can also access it through a computer. And I'm actually going to share my screen here and show you what this would look like. Go ahead and pull this up. So what we're going to do here is, so you go to www.casestatus.com and you click login, and then you just enter your phone number like so, and then you'll receive a text message with a code, and you enter that code, and then it will show all of your cases. Now, some of you do have multiple cases with our law firm, and if that's the case, it'll show each of your cases. And so you can find your Social Security case, you can click View Case, and then you get in there, you have your messages, you can see exactly who you're talking to. You can also see the timeline and an explanation of where you're at in that timeline, as well as what stages come next, so you can just keep up to date with that. And then there's also a treatment log here, which you can add treatment. What I've seen some clients even use this for migraine disorders, to log all their migraines. or for seizure disorders to keep track of each seizure. And that way when they go in to see their doctor, they can pull out their app and say, okay, I've had this many exact number of seizures since our last visit, because they have it all logged here. So it can be a very, very useful tool. Okay, so that is how you access it. What if I can't log in? You just call me or text me. My direct number is 210-951-9003. You can also email me, dustin@packardfirm.com. And if your phone number changes, then you can also just contact your case manager, tell them that you have a new phone number, and ask them to update the case status app. And once they update it, you go on your new phone, and it will save all your previous information that you entered on your previous phone. It's all together in one place, which can be very, very useful. The last question is, do I need to message you every time I go to the doctor? And the answer to that is no, you don't need to tell us every time you go to the doctor. But if you go to a new doctor that you have not told us about previously, it's worth sending a message so that we can update our list of providers for you and to see if we need to request records from that doctor. Also, if there's something very major in your medical situation that happens, it's also wise to tell us. Now, when I say major, I'm talking hospitalization, surgeries, or any imaging that has severe findings, severe abnormalities, things like that. That's worth reaching out and just letting us know. You can, some people, they like to update us more than others, but most of those updates of just regular routine visits with doctors you've already told us about, you can keep track of those in the treatment log. Okay, so that is case status. All right, so that is our presentation for today. Thank you so much for taking the time to go over this important information. I do want to let you know that what sets Packard Law Firm apart from many of our competitors is the fact that we listen to our clients. So I have some people that hire us that say, you know what, I hire you so I don't have to think about disability. So only contact me if you absolutely need something from me. Otherwise, don't bother me. And that's one extreme. I have other clients at another extreme that say, you know what, I want to know what's going on. I want you to reach out to me once a month to give me an update. So there's lots of different expectations people have about their attorneys. But again, if you tell us, this is what I'm looking for, 99% of the time we can adapt to those preferences. But again, if you don't communicate that to us, we won't know. We won't really have a chance to do that. So do let us know early. Okay, well, that's the presentation for today. Thank you again, and please let us know in the comments if you'd like us to do additional webinars like the one we've done today. Thank you and have a nice day. Bye.